Much of the concepts of natural resource law are a legal fiction. They don't make common sense. For example, Rex is right. Mineral rights, extracted minerals in the process of extracting them, for tax purposes, are considered in many instances real estate. It just doesn't make sense because they're not. That's a liquid. By the way, minerals itself is a confusing concept because minerals were generally taught in basic science classes. It doesn't necessarily include liquid hydrocarbons, but under the law it does. Liquid hydrocarbons, etc. are minerals under the law, so we're talking about that. Somebody asked me after the session this morning whether the stuff I was talking about, particularly with regard to the Dormant Rights Act, includes water. It does not include water. There are two different basic bundles of natural resources law, not counting all of them. Environmental regulations and so forth that are piled up on top of it, manifold. Water rights, natural resource law. Two different sets of laws. They don't apply to one another, and they don't work very well together. And it's a conflict sometimes because the extraction of oil, particularly in the hydrofracking and the gas hydrofracking, takes lots of water. In a recent article I wrote, I said that I thought that water was probably South Dakota's first natural resource ahead of theoretical potential in oil and gas. Water is more essential to life and it is drastically affected, particularly by hydrofracking. And the statistics on that are phenomenal. And I can get them to you if you're interested in them. I have a perspective on oil and gas leases, and I've said this before, and I'll say it here. Oil and gas leases are not leases. It's a misnomer. When we think of a lease, we think of real estate. When we think of renting land, we think of leasing land, we think of the crop share, we think of landlord-tenant relationship. We never think of an oil and gas lease as a lease. It's not a lease. It's a business contract. It's a complicated business contract. In fact, actually, it's an option contract. It should more appropriately be described as an option contract in many ways, and I'll discuss a few of them here today. Landlord-tenant law is a whole different set of law. We have a law for leasing. The law of leasing does not apply to oil and gas leases. Some simple examples. In South Dakota, we have a maximum number of years that you can lease agricultural by statute. In South Dakota, we have a maximum number of years you can lease commercial land and land within municipalities by statute. These are statutory, they've been around a long time. Many states have these maximums, so it doesn't become an eternal lease, so it doesn't become a perpetual lease, so it doesn't become an indefinite lease. We have statutes that prohibit written leases from having an extended period of time beyond that which is allowed in law. That is not the case with oil and gas leases. I gave you some examples this morning. Remember I said there are some oil and gas leases in the East Coast that are 100 years old. That's a long time. Theoretically, if an oil and gas lease becomes active, becomes operational, the contemporary term is operational, the old term, in the olden days of oil and gas law, they called it into production or in production. Nowadays they use the term operational because it's a broader term. Once an oil and gas lease, that is a non-lease, once an oil and gas contract gets into operation or production, it can go on as long as the lease permits and the operation continues. It can go indefinitely. I think about this sometimes, like, that's in perpetuity. That's what some damn professor would call it. That's indefinitely, infinitely long. That's powerful, very, very powerful. Now let me give this some perspective. The typical oil and gas lease that I see is 2 pages, 2.5 pages long. 2 pages or 2.5 pages for something that's going to last that long. That's important. It's every word is important. Everything they're doing, every phrase, every verb. I don't understand why people rush into an oil and gas lease. 2.5 pages to establish a relationship that could last how long? 100 years, 50 years, 25 years? You know, if they're operational. That's a long time to have such a short roadmap two and a half pages. The King James Version is 1,900 pages long. And that was how we're supposed to conduct ourselves. You know? So, be careful with leases. They're very significant, very serious things. Very significant. They're not leases. They're option contracts. Now, why do I call them option contracts? Well, let me say a couple words about that. But I've handed out another handout for you guys. We are not going to go through everything on that handout. But the handout is entitled, "A lease by any other name is not a lease, dash the oil and gas lease." There are a lot of terms in here. There's concepts and principles and definitions that I put in here. Some comments. This is not comprehensive. It's not meant to be legal advice, but this is a nice piece of information for you guys. It's educational. We won't go over these terms. All of them, we won't go over many of them. In fact, it's for you to read and review and make some sense of. You can do some further research. If you have questions, you can talk to me. Primary term, we hear about that. The primary term is the first period of time in the lease. Now, I'm going to use the word lease here, although I disagree conceptually, intellectually, emotionally, and honestly that it ain't a lease, it's a contract. It's a business contract. But I'll use the terms because that's what the industry uses. And when in Rome, you've got to speak Italian, you ain't going to get fed. Okay, so in this lease, there's a primary term. The primary term is the option period. That's why I call it an option. In most South Dakota leases that I see are 5 years. Most North Dakota leases are 5 years. Certainly I've seen 3 years, certainly I've seen 10 years. And I see 5 years with plus options. There's some 5-year plus 3 options and so forth. The number of years with the primary term, the optional period, is not controlled by statute. The terms, the great majority of the terms and conditions in an oil and gas lease are not found in code books, statutes. You can't go back and look at a code book. It's based on contract law, because it's a contract. It's based on case law, what little we have. And we don't have much, which brings us in, we're pioneers. And it's great to be a pioneer, but when you're a pioneer, you got to take along a lot of clothing, food, and ammunition. That means do your homework and prepare. Okay. We don't, by way of example, in South Dakota, there are only 2 cases on the principle or concept of pooling leases or unitization leases. 2 Supreme Court cases in our state. Again, there's so much untraveled, untested territory that we have to be particularly careful at the early stage. One of my concerns about many leases is that they don't have definitions of terms. Basic, simple definitions. Define what you mean. Define what you mean. Put it in a definition. They're not there, and they should be there. Let's talk a little bit about primary terms. Back there. The first period of time in the lease is the primary term. That's the option period. That's the time within which the lessee, translate lessee as operator, speculator, whatever you want to call them. The lessee is the person with the right to develop the minerals. The lessor is generally the surface owner. But it can be the mineral rights owner, because the mineral rights owner is not automatically the surface owner. Okay. The lessee has a primary term period. That's the option period. That's the time within which the lessee must act affirmatively. If the lessee does not act affirmatively, what the devil that means take some act towards development. Some act towards development. I'm paraphrasing a lot of technical terms, and it is technical, and you've got to be very careful about these terms. But some act towards development must be initiated, must be started within a primary term. If it is not, that lease is dead. Boom, over. Nada. Nichts. Nihil. Nothing. People come to me all the time with leases that were done in the 90s and the early 2000s, if they're early enough. And if they're beyond the primary term, they're not enforceable. That lease is over. Now, you have to do more research to come to that rather comfortable decision that I just made. And I would never make it so precipitous as I just made it here, but I've made it here to make a point. The point is, the primary term is the option, the election period of time for the developer or the lessee to take action. They have to take action. If they don't, they have to extend the lease. Or if there's an optional, additional add-on option, they have to exercise the add-on option. But those are usually very clearly stated in the lease. Okay, primary term. Now, Kent has correctly said some of the legitimate reasons why you as a lessee request a primary term. So you have opposing forces, naturally opposing forces. That is, the mineral rights holder has rights and positions that must be protected and advanced. The lessee has rights and positions that must be protected and advanced. This is a business deal. It's not emotional. It's not an heirloom. It's not doing it because the neighbor did it. It's not doing it because it's the right thing to do. That isn't even good enough. It's a business deal. You've got to think in terms of contracts, because it's a contract. It's one of the most extraordinary contracts in the world of commercial law, because you don't find them like this. I have actually negotiated a commercial lease, a real estate commercial lease that lasted 99 years, which is the longest period allowed in most states. That was a phenomenal thing. That was very rare, and I do that kind of stuff. That was a complicated situation, but it's just so rare that I'm trying to emphasize to be careful about what these things do, because these things can last so long. Okay, the primary term. Basically, the lessee is going to have to take some act towards development, towards drilling. Now, they don't have to have a successful will in place. Under most lease terms, they don't have to have a successful or operating well in place, but they have to be making some bona fide effort towards starting that well. I'm going to step back. Every lease is different, although you're told oftentimes that it's a form lease, it's a general lease, it's the accepted producer's lease. There's no law in any state in the United States that codifies the terms that must be in a lease. And there is no such thing as a lease that's universal. There isn't. You'll hear that, but it's wrong. And you will see leases that are repetitive and that have many terms that are duplicative and the same that you've seen before. But that's not always the case, and that's not the rule. You have to be careful. Don't get comfortable because you think you've seen it before or because your neighbor has it and so forth. That isn't the way to judge what a lease is. A lease can be any term that stays within the bounds of the code that we do have on undue influence and all that stuff. Within the general bounds of contract law, like a lease can have any term it wants in. And many of them have terms that differ from the particular property owner's term, or different companies have different terms, or different companies have different terms at different stages in the evolution of the company. You know, they find some more stuff they want to add, they find some more stuff they want to add over later. And it's very interesting watching the language change in leases. You can look at it historically, you can look at it per company, per area that they're dealing with. And some of these terms, of course, have reasonable basis in why the people are asking for them, why the lessee is asking for them. Don't get into a comfortable cookie cutter mentality when you're ever dealing with a business transaction. Even when you're going to your bank and asking for a bank loan, because every bank note is different. Every promissory note from every bank is different. And these leases can be just as different and have just as many terms in them. The lease can be extended beyond the primary term if the operations commences. Okay. Now, there are also times when the operation will stop commencing temporarily. If you shut in well, a well that might not be producing in an adequate quantity. Usually, these kind of contingencies are also described in the lease. And it gives the lessee the right to keep the lease open, active, and legitimate and enforceable, even if he's got a shut-in well, or if he's got a well that's not producing. There are several reasons that you have that leases won't be active, but the lessee will put language in the lease that will allow them to remain active. There is less and less of shut-in wells in today's world than there was in the old days, because the economics are significant in terms of the exploration costs, the drilling costs. You don't see that much of it, but you nevertheless must be alert to what happens if you've got a well on your place and then all of a sudden they quit producing. How long are they allowed to sit there with a dead well, a capped-in well, so to speak, without it producing, and yet they can start it up anytime they want later, because the language in leases does provide for the right to do that. Now, the language in most leases will have some deadlines on the action they take. And it's very important that you look at what the deadlines are. If there's a dormant well, or inactive well, or a shut-in well, you've got to look at the language, the inactivity language. You've got to look at the period of time in which the lease is inactive. How long will the lessee get, and when must they restart it again? when I'm representing a surface owner of the property owner, I'm very cognizant of these things. The contingencies that keep the lease alive must be carefully reviewed and negotiated and explained to the client, because those leases, again, have such a length of life unto themselves that whatever acts keep it alive. What's the definition, for example, of operations? Now, operations is the more contemporary term. In the old days, the old leases used to call it acts of production. Well, the definition of operations is oftentimes not fully found in a lease. That's something that should be in a lease. You should define what does operations mean, what does it not mean, what activities include operations, what initial startup activities will be included, what acts will be excluded, etc. Because operations is a very powerful term, and it's the linchpin of a lot of the activities and the keeping of that lease open. So operations is one of those very important terms we want to talk about. Royalties. Too much emphasis is placed on royalties, particularly on the property owner side, the lessor's side. It's very attractive to focus on royalties when you are being approached for negotiating a lease, because royalties is money. It's by human nature the first thing that we look at when we look at the terms of a lease. We look at the royalties, we look at the paid up initial bonus, we look at the dollar terms. Those are not the places to be looking. They're not the places as important to me as the protection of the property rights. And one of the challenges that one has is that it's hard to fight money. When the lessor comes to you and says, oh, I have $10,000 advance bonus, or $10,000 paid up bonus, or I'm going to get 15% royalty as mineral rights on it. Those are attractive. Those are attractive things, and naturally. So I too would be attracted by them and focusing on them where I am on the receiving end of such. But I can't help but advise that I believe that the functional protection for the current generation and future generation of the property, the surface rights, are much more important terms in royalty. And surface rights, if you look at a standard lease, which sometimes called a producer's ADE lease, but a standard lease doesn't really have an elaboration of surface rights in them. And surface rights should be included, it should be negotiated. Oftentimes it's done inside the body of the lease by negotiating the lease. Sometimes it's done by a supplement or an amendment or an addendum to the lease called a surface rights agreement. But just remember several things that I say today, that surface rights is as important or more so than the money you're getting. Surface rights protects the property, it defines what will happen in the event of an incident to the property, who will reimburse whom, etc., etc., etc. That's the safety mechanism of the contract. That's an opportunity to do well under the contract. We do have natural resources laws in South Dakota, as well as North Dakota. Those laws are very minimum. They're baseline laws. No statute can properly protect the property owner or surface owner. They're not comprehensive enough, and our surface damages statutes in South Dakota are minimal, from my perspective. They're not very well written, and I'm not the only one that suggests they're not very well written. And I'd say that yes, they can be improved, but notwithstanding the concept of going to our legislature and saying, let's modernize some of our surface damage laws. That's good, and I advocate the consideration of that. But you can contractually, in the terms of your lease, put in your own terms. Make your own law. That's what we're writing here is the law. It's a contract. And surface damage provisions, defining the events of damage, the occurrence, what happens if there's damage to the livestock, damage to the crops, what happens if fences are down. It's innumerable, the things that you consider and to adopt in the lease. And most legitimate lessees will work with you. They will negotiate. The mature ones, the good ones, they will work with you. They'll agree to work with surface damage agreements or surface agreement addendums. also have sometimes survey agreements, which is a separate roadmap of what you do when you come onto the property to do seismic surveying, which can be disturbing to property in and of itself. But I really am a believer in advocating and having these surface owners put in as much as they can in terms of contractual terms and contractual roadmap to protect the property. Some of the other things, just to talk about on the surface damage aspect of it. I oftentimes will suggest that the surface owner ask for an indemnification clause, which will allow indemnification if the liability or damages that might be caused or assessed or fined to the property because of what the operations are on the property. I often request insurance, carrying liability insurance by the lessee and so forth. We have, again, in South Dakota, we have statutes that address some of this, but if you look at the bonding statutes in South Dakota, $2,000 for a bond for the initial permit on a well. As I said to somebody in Buffalo, $2,000, there's some trucks, you can't replace the tires on the trucks for $2,000. What's that going to do as a bond? I'm not a believer in bonds. I like to say, by the time somebody has to exercise on a bond, there's already been a funeral. There's already been so much significant damage or a problem that you're just trying to get some residual benefit from the bonding. I have rarely seen bonding act as a full recovery in terms of the damage that occurred that caused the bonding to become effective. Commercial bonds, well, even in construction contracts, by the time it gets to the point that the bonding company is putting up money to get a new contractor in to fix the problem, that problem is there. That problem is extant, it exists, it's got to be fixed. And bonding is like after the fact trying to fix it. So I believe that a couple of concepts can be addressed to deal with that. And one is an indemnification clause in a lease. Another is a general liability, which is immediate, much more immediate than bonding. If anybody's ever been through the experience of, petitioning to apply for a bond to become effective and pay out, oh boy, that's, you might have to read Charles Dickinson novel. It takes that long to get the damn thing. It's just not efficient. It's not businesslike. So bonding isn't a cure, and the bonding statutes in our state are inadequate in terms of what they're trying to cover and the amount of the bonds. But for sure they are. Okay. I'm not here to make light of royalty. The concept of receiving royalties, getting royalties is lovely, it's wonderful, it's high class. That's why people have to drive around in what they call Mercedes-Benzes. I'm not against royalties. So I will say a few things about royalties. Calculate, make sure that you all calculate, because most people in the audience today, I will assume, are a surface owner on that side of the fence. So that's why I'm directing my comments this way. But when you're determining how the royalties are going to be received in a lease, be careful, because the methodology of calculating that is complicated. Actually, it's more complicated than some of the stuff that Rex was talking about. It's as contractual in nature. It has to do with old Texas case law, at the wellhead, at the pipeline. Those are technical legal phrases. Unless you're in the industry and you have nothing else to do with your life, you're not going to care what they mean, but they're significant because they determine when production costs become deducted from the royalties and when they don't become deducted for distribution of the royalty. Those are some things that you need to consider when you're negotiating a lease, and those are some things to think about when you're on the royalty side. So lots of stuff is buried in 2.5 pages. Lots of stuff. And it's, while I'm not suggesting it's illegal, I'm suggesting it certainly should be reviewed. It's contractual. They have the right to offer it, and the landowner has the right to agree to it, but that doesn't make it favorable. It makes it something that must be reviewed. So we talked about duration. You hear sometimes about delayed rentals. It rarely happens today because we don't have that many shut-in wells generally, and we don't have installment payments on this. The typical 5-year lease, in the olden days, you wouldn't get a paid-up bonus for the 5 years. You get a paid-up lease. I mean, in the olden days, you would get installment payments. You get an annual payment, first year, second year, third year, fourth year, and so forth and so on. But nowadays, most leases are just do paid up bonuses, where they just pay up front a nice lump sum, usually it's a nice handsome check, gets you excited. Then there's no more payments during that 5 years unless there's an incident relative to operations that occurs. So it's a one-time payment for a 5-year option. Think of it that way, because that's what's going on in many of the leases. Most of them have been in South Dakota are 5 years. Some 5 plus 3 with a 3-year option. Usually the option has another consideration point. You get another payment at the third for the extra 3 years. But it's another standby kind of an option where the lessee can then stand by for another 3 years until the market is right for him to develop it. And again, the lessee has a lot of legitimate strategic reasons why they might want to defer. The availability of rigs, the market price of the gas, the market price of the oil. Gas is much more problematic because you see more shut-in wells in gas because that price is all over the place, and usually lately it's pretty weak, and consequently you'll see more shut-ins. Rarely see them today on oil. The dry hole clause in the lease is another clause to think about. What a dry hole clause is and does is that if you're in your lease period and you come to a dry hole, you get a little extra bonus extension if you got a dry hole. You can start drilling again. You can start drilling again as long as you're in that bonus extension, because you legitimately tried to drill a hole but it came up dry. And you might be past the 5-year primary term, but if you had your dry hole started before the primary term and it was you were trying to do it and it came up dry after the 5-year primary term, you get a little extra bonus extension where you can pop another hole in the ground and do it again because you're playing honestly, playing good. It's a dry hole extension. So there are lots and lots of interesting terms in the lease. One of the more phenomenal, what time is it? How much time do I have? They won't give me any more. Okay, I'll wrap up. The problem, the leasing is a dilemma, and then I'll end it with this. Leasing is a dilemma because you can be forced into a pool. A reservoir is a pool, and they go by different names. Reservoir, pool, it likely doesn't matter what you call it. There's a field, a subterranean field that's worth exploring and exploiting. That field is oftentimes in legal terms called a pool. You might be forced into that pool whether or not you have a lease with somebody. So sometimes it's better to negotiate a lease rather than to forego doing leasing, because you can control a little more a roadmap. You've got your own roadmap with the lease. Where if you were compulsorily pooled non-lessee, you have a problem because your rights are only those bare minimum rights that are allowed by statute. And if you have a lease in place, at least you've got additional contractual rights that you can use for your benefit, and you can use to exercise or hold the other party, that is the lessee or the developer, accountable. Lots and lots of other things, but my article will give you lots of ideas. And again, if you have questions, there's a question period afterwards. Thank you, guys.